saying there's no amount of bond he can make. He needs a PR bond. Is that correct?
Yes, sir.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
Your Honor, you were most kind, and I thank the court.
All right. So Norm, I want him evaluated for a PR bond, and then we'll place him back on the docket as soon as that completed. It should be done by next week, hopefully.
Not a problem, Judge. I'm here every day.
All right. Thank you.
Thank you.
Morning.
Good morning.
Thank you for dressing appropriately for court. So let me see. All right. So discovery, was that completed?
Yes, Your Honor.
All right. And today is the plea deadline date. So is this going to be a jury trial, or have you all reached an agreement?
We have reached an agreement, Judge. There's one caveat that I should explain to the court.
Yes.
We're in agreement with all the terms. It's been a written plea agreement. We've gone over it with Mr. Lunsford. We do have an agreement. One of the things that the state wants to accomplish prior to the plea is restitution up front. The state, and I don't want to speak for them, but my understanding is they need a little time not only to identify the specific recipients of the restitution by name, addresses, who the check should be made out to, and the amount. It's a substantial amount of money, and we are able to pay that before sentencing. So I would suggest perhaps 30 days to get those numbers done so that we can present the agreement to the court.
Let me make a suggestion. I would suggest that you all do the plea today, and I will set it in 30 days for sentencing. And then if for some reason and it will be set for a restitution hearing before the sentencing. And then if there is an objection to the restitution, if there's an issue with the restitution, we can handle it then.
Part of the people argument is that it would be paid up front. So as long as the before sentence is imposed,
yes,
then that'd be acceptable to the state.
All right.
Yes.
So then that way, once I'll take the plea today, the sentencing would not occur today. And I'm assuming there's no need for a PSI or TAP evaluation, or is there a need for that?
I think there is, Judge, because some of the terms and conditions, there are going to be things left up to the court's discretion. And
all right. Well, what I can tell you is, sorry to interrupt, but what I can tell you is just to cut through things, a PSI is going to take 8 to 12 weeks. So we can enter the plea today, and then it'll be 8 to 12 weeks. That'll give everybody plenty of chances to get the restitution amount, and you all can confer off docket. Is that good for everyone?
That's fine with the state.
Yes.
All right. So if you guys will get the plea paperwork ready, I'll take the plea, and then we'll set it for a sentencing. What date would that be on, Ms. Ferguson? Well, no, it's going to be a PSI and TAP evaluation, because that will give you more time with a PSI and TAP.
Yes.
I can do it. So it'll be October 20th. And what I can tell you is PSI and TAP, those are two completely different things. So they're going to be two completely different dates for you to see probation. So make sure you meet all of those dates.
Yes, ma'am.
So October 20th, is that good for everyone?
Judge, I have a federal trial that day, but I don't think it's going to go. If we're a couple of weeks out, that looks hard, then I'll talk.
Okay. All right. So we'll set it for October 20th, and I'll wait for you all to do the plea paperwork. Once you've completed that, just let them know and we'll take it out.
Thank you, Judge.
All right. Thank you. Who else? All right. Court is going on the record. Court is calling 2025 CR 1023 State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Sam Cogdill and Sam Log from Splunks.
And are you Mr. Lunsford?
Yes, Your Honor.
Counsel, have you received all discovery, and did you review with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes,
Counsels, do you waive the reading of the indictment?
we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections? Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with Money laundering. Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with him, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, sir.
According to the plea bargain agreement, the state is proceeding on count 1. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Counsel, could you all check the box here? An
Yes, sir.
initial. Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was going to recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yeah, ma'am, you just, as I
Sorry.
said, they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand? All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to count 1, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
No contest.
State any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first-degree felony, but it is for money laundering over $300,000, not less than.
All right. Thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Sure.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, there's a stamp over the discovery.
I saw that too, Judge, a postage stamp that made its way into the document. I wasn't sure what that
So
was
I'm not
about.
able to read that. If I lift it, it tears.
I can get another copy, Your Honor. It's going to take me a little while.
All right, no problem.
Okay.
So Mr. Lunsford, what's taking the court a while is that because this is submitted to me, I have to find that there's sufficient evidence to find you guilty. So I have to do my math to make sure this adds up. All right? All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record? All right. Once you sign the reset form and speak with probation, you'll be excused. All right. Thank you.
Thank you.
Thank
Your
you.
Honor.
Mark.
But the one time I did roll my R, everything just went haywire. So I don't think the universe was expecting it. All right. So today is plea deadline date.
Yes, Your Honor. So we were recently hired on this case,
Mhm.
just a couple days ago. We still need to go through the discovery, and Ms. Laraga has informed me that she has previous experience at the mental health court. We need to explore that also, if we could. So if we could get an extension on this plea deadline, we'd appreciate that.
All right. Who's the prosecutor on this case? Shakira Laraga? Right. Did you confer with the state?
Yes, just briefly, Your Honor, just to let them know that we've been previously, just recently retained on the case. So we need to evaluate the discovery.
All right. So today is plea deadline date for them. She's previously been in a treatment court in the county court. And the last time we were here with this, there was supposed to be a consideration of the fact that she was in a treatment court.
We were just hired a couple days ago. I didn't realize that's been previously brought up to the state.
Mhm. So, Ms. Ferguson, set this for the second week in September, and that will be your plea deadline date.
Thank you, Your Honor.
Thank you, Judge.
What date? All right, September 8th. Thank you for addressing appropriately for court. All right, just have a seat and your attorney will bring you a reset form.
Thank you, Your Honor.
You too. Have a great day. All right. Yes.
I believe you had a discovery setting. The very first initial setting was a discovery setting. At that
Yes.
setting, we got a offer from the state that was a time release. We conveyed that offer. I believe we have received all discovery. I've tendered a discovery acknowledgement to the courts. And I believe the client wanted to address the court, but he formally rejects the offer.
All right. So do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that
No, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you, that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here will hear whatever evidence is presented and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically, and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about date, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
I don't want us to take what the state is offering me, because it's, I don't think prison is.
Here's the
I
thing.
would recommend.
Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They'd be like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state, because ethically, I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state, who's the state on this case with Jacob?
I confer with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
It's just the case that we discussed. Okay, yes, something. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No.
That would be today only offer, since
All
would
right.
be
And
changing.
that's how I feel in track. Like,
All right.
I feel like I got an ultimatum. And I feel like if I hired another lawyer, I have a better chance to, get a drug program, because the whole reason why I'm not running from what I did. I
wouldn't seek further, but don't admit any guilt. Just please don't say something. Your Honor, we were here on a prior setting earlier this week. He had some time to think about this.
Mhm.
I know Jason is leaving.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box, and then I'll bring you back up at 10:30. And you need to let the court know whether you're accepting, if you've reached an agreement, or whether you're going to jury trial. Those are your options.
Okay.
All right. Thank you.
Discovery wise, we're fine, Judge. My client wants to replace me with different counsel. He's not cooperative with me. He has suggestions which I disagree with. And he's got a pro se motion in his hand wanting to replace me as counsel.
All right. So are you going to hire your own attorney?
I was seeing it up in from what he different from me.
No, this is your attorney. And so here's the thing. You can either talk to your attorney or not talk to your attorney.
It's not that me not wanting to talk to my attorney. He's been given certain types of evidence that he's not willing to share with the DA, messages, things that have happened to my wife.
Let me ask you something. Here's the thing. Maybe if he is not sharing something with the prosecutor, maybe it may be because it's in your best interest that it not be shared. So I don't know anyone. This has to be the only profession where people get an attorney and they think that we have no knowledge, that all we're doing is talking. But there's a lot of knowledge behind that. And everybody thinks that they can be an attorney without having gone to law school. I have yet to meet anyone who goes to see a doctor, and if they're ill, they go to the doctor and then they get their second opinion or whatever. And then they say, you know what, doctor, I know better than you. So this is your attorney. If you want another attorney, you're more than welcome to have one, but you will have to hire that attorney. Do you understand?
Yeah.
All right. So we're going to set this for a plea deadline date. Norma, set this for a plea deadline date, the third week in September, please.
If I can speak freely on,
I don't know if your attorney wants you to speak freely, but I was willing to listen.
Judge.
there's a person that this happened to on this case has made false police reports and everything else.
Mhm.
He's not willing to share any of this with the DA.
Big state. He's saying that somebody made a false police report on this.
Not to my knowledge, Your Honor.
January 25th. You haven't told him anything, right? You're refusing to
All
show him
right.
anything.
So we're going to come back on September 18th. I'll need an acknowledgement of discovery completed. All right. So we're going to bring you back on September 18th. September 18th will be your plea deadline date. And then next date will be a jury trial date.
That'll work, Judge.
All right. Thank you.
Thank you.
Counsel, you received all discovery. Did you review it with your client?
I had, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated with a child under 15. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she does.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering this plea, if you're not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the United States?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends the state recommends community supervision. They're taking in consideration 2025 CC 011952, and there's to be restitution to Victor Flores. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a top evaluation, 100 hours of community service restitution, ignition interlock for half the term, 2-year license suspension, parenting classes, AA meetings, and UAs. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State moves to admit what has been marked as State's Exhibit 1 in all attachment.
No objection, Your
All
Honor.
right, state, you may be excused.
Good.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I mean, this is her first criminal offense. I mean, obviously, situation she is at right now that the court has her attention. I believe she's going to be a very good probationer, and you're not going to hear from her again, Judge.
All right, so how often have you been drinking?
I haven't since then.
All right, so here's the thing, and I tell this to people all the time. When I was a defense attorney, I never had a client who said, my intention was to go out, get as intoxicated as I could, drive, hit someone. I've never had anybody say that. But the problem is when you go out drinking, you lose control of your normal faculties, both mental and physical. And then you go out and you hit somebody. And you had a child in the vehicle that could have easily been a dead child. That could have easily been a child that was severely injured, because usually, and I haven't done the statistics on this, my professor would be upset with me for saying this, but normally what I see, the person who drinks and drive, they usually end up walking away. The passengers end up being injured. The person they hit ends up being injured. You just have the soccer mom or the grandfather who's just enjoying their life and somebody's drinking and they hit them. You're one of those people who cannot drink alcohol at all. And while you're on this probation, you're not allowed to drink alcohol at all.
Yes, ma'am.
So don't drink. You don't need to have alcohol to have a good time.
Yeah, and I've been sober since then. I haven't touched any beer, nothing. And I'm not trying to either, especially because of my kids and my granddaughter.
Okay. All right. This is what the court is going to do. The court is finding you guilty. Are you employed?
Yes, ma'am.
What do you do?
I work at O'Reilly's.
Auto parts.
Yeah, parts.
Okay. Well, you know about, now that song is going to be in my head forever. Thank you a lot.
But mine too, Judge.
That song's been in my head, especially because I did the parade for work.
So do you sell parts and give people
Yes.
advice?
I'm a dispatcher. I sell parts. I pull parts. I make sales, everything, basically.
All right. Court is going to sentence you 2 years in the state jail facility, suspended and probated for 4 years. There's a $2,000 fine that will be probated. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be a TAP evaluation out of custody. Follow TAP recommendations, with the exception if they recommend inpatient treatment, we'll start with outpatient treatment. There's going to be 30 sober meetings in 30 days. 100 hours of community service restitution. I'm going to order the parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. Field visits 1 time per month for 3 months. Ignition interlock for half the term. A 2-year driver's license suspension. The victim impact panel live DWI education course. And there's to be restitution, if any, to Victor Flores. Norma, I need a restitution hearing in 3 weeks, please. That's 3 weeks? Yes. No problem. I was like, are we already there?
Oh, I'm fine.
All right, September 16th, the state is going to come in. State on this case, September 16th, that will be our restitution hearing. Taking consideration 2025 CC 011952. Probation, is there anything else?
Ma'am.
All right, is there anything else you need from the court to be successful?
Just anything that what I could do to stay out of trouble, which I still have been.
All right, just make sure you communicate with probation. That's a big start, okay? If there's anything you need, just let us know. Let probation officer know. If you feel as though they're not addressing it, you can come back to court. Do you understand?
Yes, sir.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. And does she only have a warrant on this case? All right. So, and the court will recall the warrant. All right. Thank you. All right. So, sir, here's my question for you. Are you on probation?
Yes.
So why do you think that if you're on probation, you get to make your own decisions without contacting probation beforehand?
No, ma'am. I've been in contact with my probation officer. I let her know that I was going to be losing my apartment, that I had permission to travel to Fredericksburg.
Oh, and did she say you could move to Fredericksburg?
No, ma'am. I was starting to stay there in the weekends, and I lost my job.
No. See, you're not internalizing what I'm saying.
Yes.
Did probation give you permission to move to Fredericksburg?
Eventually, yes.
But no, before the move.
Well, I was staying there. I was spending the night there visiting, but I was not staying there. I still had
Did probation give you permission
to travel? Yes, ma'am.
Now, my question is, did they give you permission to move to Fredericksburg? That's either yes or no.
I'm not live there, no, but I was visiting.
All right. So again, you are on probation. Why do you think you can just do what you want to do? I'm sorry.
I don't think that, ma'am.
But your actions are saying something different. You are not allowed to move to different places without probation's prior permission. When you're on probation, that is a contract. It does you no good to ask for forgiveness rather than permission. While you're on probation, you have to ask for permission. Because when you're coming with probation and you're asking for forgiveness, you know what that results in? That results in me getting notice that you're asking for forgiveness, which asking for forgiveness is a violation of your probation. So you need to ask for permission prior to making moves because you're under contract. You understand? Probation. Are there any other concerns? Has anybody received any type of documentation that he is actually now living in Fredericksburg? And then we have on this supplemental report that they made contact with you for 4 field visits. And they attempted to complete the field visits, but I'm assuming you were not there.
I mean, my work schedule had me away from home.
Did you tell them that?
Yes, ma'am. I had text messages where I was communicating with a visitation officer, and I let him know the situation, my work schedule, and I also let my probation officer know.
Here's the thing. I don't know why they would put in their report they're attempting to make field visits if you made contact with them and said, I'm not going to be there.
They called me and they sent me text messages. And
Call you and said, where are you, right?
Well, they asked me if I was home, and I said, no, that wasn't work.
So that's not, that again, that's, you're not understanding what permission is. Yeah.
Were signed on August 25th, addressing just transfer to reside.
This copy of
You cannot, I repeat, you cannot ask for forgiveness anymore. Do you understand? You're going to have to ask for permission. The next time you ask for forgiveness, what's going to end up happening is I'm going to receive notice. And in that notice, they're going to ask, should we do a compliance hearing? What should we do? And if it's the same thing where you're not following through and you're just living your life, and I know people just want to live their life, but when you're on probation, you just can't live your life like everyone else because you're on probation, you're under contract. You understand?
Yes, ma'am.
So no more asking for forgiveness. You need to ask for permission. Now, is there anything else you need from the court?
No, not this time.
All right. So probation, you sent me this supplemental report, and they were asking for Sabbath is listed on here. So your conditions include intensive outpatient treatment. So have you been doing that?
My probation officer is waiting to get back to me, and I told her whenever we're available to start that I'm ready to start that. I've completed the 120 days. I started to look into parenting classes online and other resources online, so I should start taking
All
care
right.
of that.
So you need to start
And
intensive outpatient treatment ASAP. Anything else?
no, I was going to finish by saying that I spoke with the probation officer. She said she was going to get back to me as soon as she heard back from outpatient or whatever office.
They're here.
People were going to set me up for that so that I can start those classes on.
So you're going to start it, okay?
Yes, ma'am.
Anything else, probation? No. All right. Thank you.
Thank you very much. For
You're welcome.
Have a great day, ma'am.
Thank you. You too. Thank you for dressing appropriately for court.
Yes, ma'am.
Good morning. How are you doing today?
I'm hanging in there.
Oh, you got to do better than just hanging in there. Life should be about more, right?
Should be.
All right. Yes, counsel.
Judge, my understanding is we're set for a probation status. I talked to probation this morning. It looks like Mr. Kitchen's probation was transferred to Taos County. One of the conditions was that he enroll in Veterans Court. And it looks like he hasn't enrolled in Veterans Court. When I talked to him about it, and I think in conversation with probation, it looks like Mr. Ketchum has let me know that he doesn't qualify, or he's telling probation that he doesn't have any substance abuse problems. And so he doesn't want to give up his spot to a veteran who does need substance abuse program treatment. And I believe that's why we're here this morning, Judge.
All right. So here's the thing. We were here. I remember your case. You're supposed to be going to Veterans Treatment Court there.
Right, they didn't accept me into the program. I don't have a drug or alcohol problem. I've been very vehement with my former attorney who I fired due to malpractice.
No. So here's the thing. You're supposed to be in Veterans Treatment Court. That's where you're supposed to be. And Veterans Treatment Court is not necessarily 100% about drug addiction. Sometimes it's about mental health issues and other things, but that's where you're supposed to be. And I remember you, and we had a long conversation concerning this. Could I see his file, please? Yes. And we were here and I said he would not be allowed to transfer to Austin unless he was monitored in court. And his attorney was here and we went over these long hearings about his being transferred so there could be a smooth transition to Veterans Treatment Court in Austin.
Understand, Your Honor, and I spoke to the individuals over there and they denied my entrance into the
Oh,
program
I'm sure they will deny it if you say I don't have any problems.
because I don't have any drug or alcohol.
All right, so here's the thing. You're not going to be living in Austin.
Understand?
So he's not going to be living in Austin because those were the rules for in order for him to reside in Austin. And you come before me and then you go somewhere else. I don't have a drug problem. I don't have a mental health issue.
I never stated I don't have a mental health issue. I've been seeing the VA regularly.
Yeah. So he's supposed to be in the Veterans Treatment Court in Austin Council.
Sure.
That's where he's supposed to be. And if he's not going to be in that program then he's going to have to be here.
Okay.
For supervision. So it's up to him. That's the last choice he would have.
So the body's on the plan for the network. Put all the and all the pieces. I've done everything. I've seen this. I'm going to get 55.
One of the conditions.
Nor 40 of the people have been to do a program on deny me program. I can only be honest with them, and I've been honest with them. And they deny with program.
Get to go back.
So then how much longer do I have to this program, this program? I'm trying to get on with my life. I've lost everything. I've lost my favorite animal. I've lost my home. I've lost my possessions. I have no family left.
Yeah, my heart.
I'm doing the best I can under circumstances that are way beyond my control.
All right. So I'll let you all discuss that. All right. Thank you.
It's overlooked.
All right, Council. Yes.
Judge, after confirming with my client, he's indicated to me that he's going to choose to remain in San Antonio and get money. He's elected not to go back to Austin and participate in the Veterans Court program.
All right. State. This is Tyler Richard Paul Ketchum. And I don't believe we were here for a motion to revoke. It was just compliance. Is that correct?
Yes.
All right. So his conditions are going to be altered and amended to include a return to Bexar County. And he will be supervised here in Bexar County. And if you all can do an updated TAP evaluation. And also see if Veterans Treatment Court here will accept him.
Okay.
All right. Is there anything else, counsel?
Not from defense counsel, John.
All right. Thank you.
Thank you, Judge.
Thank you. All right. So he has a motion to revoke.
Yes, Judge.
Yes.
But we're here to resolve that. Judge.
Okay. All right. The court is calling 2022 CR 6213 State versus Justin James Gonzalez. Can I have parties announced for the record, please?
Rick Pena for the state of Texas.
Orlando Costa, Northbridge Defense.
And are you Mr. Justin James Gonzalez?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Justin James Gonzalez who was placed on deferred adjudication in 2022 CR 6213 for the offense of aggravated assault with a deadly weapon on September 20th, 2022 for a period of 7 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 2. On or about the 16th day of July, 2024 in Bexar County, Texas, the defendant, Justin James Gonzalez, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
He pleads to that. True or not true?
True.
State will waive the remaining violations, Your Honor.
Any objections to the waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor, and that is to deny the motion and alter and amend conditions to add safe P followed by safe P aftercare.
That is correct, Judge. We were here about 10 days ago. Mr. Gonzalez, at that time, we were going to go forward with this motion. He wanted to take that 10 days to allow me some more time to prepare because I had just been assigned that day. I met with him at the jail and we discussed this case. My belief was that these violations, there were some issues, I think, improving that, he did participate in one of the classes, and we needed to get, I guess, payment to them to provide the certification of completion of one of those programs. He was in the process of enrolling in parenting class. He told me that, he had done 90 days cognitive with ISF, but he had not done a substance abuse track, and that he actually wanted treatment. And so it kind of took me aback because I didn't believe that's where we were at when I first met with him. He said, no, I want to be treated. I want to get treatment. He was very motivated for treatment. He was asking for 90 days substance abuse track. If not SATA, speaking with the state agreed that if they were going to make a recommendation, that it would be for Safe P. Even knowing that that's a longer program, Mr. Gonzalez said, I want treatment. And so I believe he's motivated for treatment and that wants to help get past any of these substance abuse issues that he has.
All right. So I'm going to give you a choice. You know yourself better than I do, better than probation does, better than your attorney does, right? But you're going to have to be 100% honest with yourself. You've been before me previously on a motion to revoke. So these are all your only choices. There's no other option. I can deny the motion. I'll alter amend conditions to have him go to safety. I don't believe he's going to be accepted in felony drug court based upon his tattoos and their meaning. Or I can revoke you, and I'll revoke you, and I'll sentence you to 7 years. Those are your two choices.
Safety.
All right. So the court will deny the motion, alter amend conditions to include Safe P and the aftercare program.
Yes, sir.
And upon release from Safe P and the aftercare program, he's going to do 90 sober meetings in 90 days.
Yes, sir.
All right. Is there anything else that you need from the court to be successful?
No, Your Honor.
All right. Probation, is there anything else?
As far as the pending case out of Comal County, you know what's going to happen?
I don't. It was a driving while license and all that.
Just because he'll be in limbo
No. Yes.
until that case is resolved. So we can do the referrals, but
I don't believe it's been filed.
Well, if somebody could reach out to Comal County,
Yes, sir.
I'm sure a driving while license suspended, maybe they will take care of that.
Okay.
All right. So what we'll do is, Norma, recall this for the end of September, just to make sure that that case has been taken care of. If it hasn't, we'll need to do something because otherwise he'll just be sitting at the jail.
Thanks.
All right. So we'll be back on September 29th. However, if that Comal case has been taken care of,
He's on bond, he says, on that particular case.
but still it's pending.
Yeah. Okay.
So if by September 29th, that case has been taken care of, we won't have your hearing in this court. You'll just be waiting for a bed at safety. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
You're welcome. State versus Eduardo Escalera. Could I have parties announced?
Kurt Fania for the state of Texas.
Frederick Nair from Mr. Solera.
And are you Mr. Escalera?
Yes, sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Eduardo Escalera who was placed on deferred adjudication in 2020 CR 0291 for the offense of violation of bond or protective order 2 or more times within a 12-month period on August 2nd, 2021 for a period of 3 years? Is that you?
Yes, sir.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and invoke community supervision. Violation condition number 20. On or about the 11th day of July, 2025 in Webb County, Texas, the defendant, Eduardo Xavier Escalera, did then and there fail to register for, attend a parenting program with the approved agency in violation condition number 20.
How do you plead to that? True or not true?
True. The state will waive the remaining violations, Your Honor.
That's what I'm understanding.
Any objection to the waivers? Did you understand by pleading true to violation of condition number 20, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
Yes, ma'am.
Court will find violation of condition number 22. Is there proposed agreement?
There is, Your Honor, and that is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 2 years prison.
I'm sorry, how many?
2.
That's the agreement, Your Honor.
Are you asking the court to follow that agreement?
Yes.
All right. Has he done anything on probation? Has he completed anything?
I did my community.
You want to raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hands.
I finished my community hours at SATF. I attended SATF. I completed SATF. I also I enrolled to my VIP classes, but they made me start over because I missed, I think, 2 weeks. So they made me start over again.
So why didn't you complete your parenting classes?
Well, it's because in Laredo, your kids have to be a certain age to attend it, but I was going to start with the same professor there, but I had to finish the VIP classes first.
The problem is primarily drug abuse, Judge. Frequently, he was extended a year ago for a year. Since then, is concerned most of the violations have been either a failure to show a positive or diluted in drug tests.
I did attend an outpatient program that I emailed a certificate to my probation officer in Laredo, and I think she emailed it over here. It was called SCAN, and my counselor there was Carlavela, and I did it for 6 months with drug testing and everything.
Mm-hmm. All right, probation. What are you requesting?
Probation's recommendation is to extend him for 2 years or to attend the safety program.
All right.
That's a fact, but it is.
Here are your choices. These are the only 2 choices you have.
If I may, Your Honor, before you.
Yes.
I just want the court to be aware, as far as what probation said, his probation did expire at the beginning of this month.
Okay.
Sorry.
All right. So here are your 2 choices. These are the only choices you have. I can revoke you. I'll sentence you to 3 years in the prison. You get credit for any successful completion of inpatient treatment because legally I'm required to do that. Or I can revoke you, find you guilty, and grant you probation, but you'll be going to safety.
So it's the 3 years, not 2.
Yes.
And how long is safety?
I'm sorry?
How long is that program?
Well, you have an aftercare program that I believe is 3 to 6 months, and the actual program in custody is 9 months.
Okay, I'll do that.
I'm sorry?
I'll do the safety because, well, I thought I was going to do the 2 years in TDC.
You want to discuss it with your client?
Let me discuss it with him, I may, Judge.
All right, so I'm going to let your attorney discuss that with you. Counsel, you can discuss it with him and you can appear by Zoom if you can't be back this afternoon. All right, so the court is going to, you're welcome. So the court is calling 2025 CR 007563, State versus Ronald Lamar Allen. Can I have parties announced?
Lauren Smith, State.
Charles W. Booker for the accused. Ronald Allen.
All right. Counsel, you received all discovery?
Yes, I did, Judge.
And did you review that with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Allen, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, I did.
Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes, I did.
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Allen, did you review the court admonishments and waivers with your attorney?
I did.
Did you understand it and sign it in all the appropriate places?
I did.
All right, you're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
I do.
Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization. Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
And counsel, I believe we had any pretrial motions?
We did have some trial motions previously in this case, and they've been disposed of.
All right. Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State tenders what has been marked States Exhibit 1 and all attachments.
All right. Did you review any objections?
I have no objections to those pieces, Judge.
Mr. Allen, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right. Any objections to the court reviewing? Okay. All right. Yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. that letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services, and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos, and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr. Allen.
I'm just saying, the judge's notes that you gave me, they have these people listed underneath protective order.
Judge, I don't think that's accurate at all. I think that's being misread right now because
I mean, that's the only way I can read it, and the reason why I'm saying that's the only way I can read it is because it lists Medley, it says protective order, and then indented right underneath, it says M. Medley, which is the state has outside the agreement. They're asking for a no contact order with that person, with Charles Ireland. And then they have someone by the name of Gallegos and Ramirez.
Right.
And then right after it says that it has protective order, then right after it mentions those three names, then again, it says 2-year protective order granted as to, I believe that's the mother.
That's the mother's name. Yes, Mrs. Allen. Yes. But there is no protective order granted in that order regarding Mark Medley, regarding any of those people. The only one that has a protective order granted against is the mother of the child that we're talking about here. Ms. Gallegos is here and she hasn't asked for a protective order. And we know that the amicus doesn't have a protective order either.
Okay, so this is what I'm going to do. I've taken your plea. And if somebody can tender to the court, whatever the orders are on the civil side, I'll review those, because those judges' notes that were handed to me appear that there's a no contact order. And I think you want to have those.
Right, exactly.
Know for sure whether it is or not, because otherwise you may be violating orders over there.
Absolutely, absolutely. Black and white.
So what we're going to do is I've taken your plea. If you all are waiving PSI, I won't set it for a PSI. We'll just come back when I'm back. I'm going to be gone the first week of September because I have to go to a judicial conference, have to keep up my educational courses. And then the second week I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September. And that'll give everybody a chance, and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Medley listed as a no contact person too.
Well, and absolutely. And we understand that Mr. Medley called and asked for that kind of to be added to this order. That's my understanding from my discussions and my review of the state's file. But, I think the reason you see this line that says protective order plus merits is because that is what the topic of the entire, and what you're seeing here is actually the litigants that are, or the attorneys representing each of these litigants.
The best way to discover what that means is
yes,
the judge.
I just have one request. We have services from my father September 5th. And I'm on the
go to the services.
Yes, thank you. Yes, absolutely.
But here's the thing about going to those services, and state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order and I will do the style and you all need to write down your agreement.
Okay.
All right.
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson.
Yeah.
When can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side.
Yes.
So that this could a little bit be in harmony.
Absolutely. I agree.
I can do the 16th.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case.
All right.
In order to make their orders. And that's one of the reasons Ms. Gallegos is here.
All right, Ms. Gallegos, if we can go off the record, Ms. Gallegos, if you'll come up. All right. Hello, how are you doing?
Yeah. Good for you.
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes, the way it's written, it appears that you're a part of the protective order. Metley is a part of the protective order. So if the court can get clarification from the judge on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly appreciated.
Okay, we have a conference call next week, and then we will be looking to get it entered. We are hoping to obviously do it as soon as possible, and we will try to meet your deadline of the 16th. And I'll let the other attorneys know. If not, do we need to send an email to Ms. Ferguson?
No, I mean, I'll just need that information before the 16th. So if you all can get the judge if you all want to, you can have the judge email me and say, this is who's a part of the protective order. Or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me this is the part of protective order, because the way the judge's notes are written, it's so.
Okay.
Oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's the petitioner. Margaret Gallegos, me, I represented the respondent, and then Anna Ramirez was the amicus. Yeah, and then it goes down.
The reason why I say that is because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that print out one more time? So that's why I need clarification, because the way that's written in the judge's notes, as you can see, it has a title protective order. Then it has a list of 3 people. Then underneath that list, then it comes back with a 2-year protective order. So it seems as though those are the people that he has a protective order against. So I would prefer that he know, I would prefer that I know, and probation knows.
So on here, it says 2-year protective order granted as to Mrs. Allen.
Yeah. But above it, it says protective order.
Okay.
So if you all will fill in the dates for him, please, and what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right. And if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right, so we'll come back on September 16th, and at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation?
I would.
All right, so thank you.
Thank you, Judge.
All right,
Thank you.
thank you.
Thank you so much. I appreciate it.
And thank you for dressing appropriately for.
Absolutely. Absolutely.
All right, and you're not excused until you sign the reset form, okay?
Absolutely.
Thank you, Judge.
All right, thank you. Yes. Probation, there's no PSI or TAP on that. He's all right. The court is calling 2025 CR 0018230 State versus Juan Cruz. Can I have parties announced?
Ashley Jones for the state. Christine Brown on behalf of Juan Cruz.
And are you Mr. Cruz?
Yes, ma'am.
Counsel, you received all discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery and there are no applications, correct?
There are none.
Okay. Mr. Cruz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We waive the reading of the indictment. We did want to note that the state is moving to amend it, and we waive that 10 days notice attached to that amendment.
All right.
Yes, Your Honor. The state is moving to amend the indictment to reflect the correct spelling of the pseudonym name as well as the word pseudonym.
Mhm.
So we are just changing that. And then additionally, we are proceeding only on count 3 and we will waive
Mr. Blinko,
all
I'm
other
going to show you
counts.
what's entitled Application
Further,
for
we are
Community
waiving the
Supervision.
habitual
Did you
enhancement
review that with
application.
your attorney? Did you understand it and did you sign it?
Yeah.
That's either yes or no.
Yes.
All right. Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Blinko, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with the offense of robbery? If the state presents evidence that proves the repeater paragraph, And the then your range of pseudonym, punishment will what be is the anywhere correct from spelling? 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
And
If you have a
defense,
plea
you have-
bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Blinko, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. State recommends community supervision. Did you understand that to be the plea? Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
Any such questions?
Any
such questions? No, Your Honor.
Thank you. Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Jeremy Fierce, Fearce, Juan Mello, Mello, Anthony Koschansky, Kochanski. Did you understand those are recommendations from the state and the court does not have to
Yes,
abide by those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest?
no contest.
And to the enhancement allegation, how do you plead? True or not true?
True.
State any evidence to support the plea?
Yes, Your Honor. State Exhibit Number 1 with all of its attachments.
No objections, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes. Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true in States Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Two things, Your Honor. One, may I present this folder with a few
Yes.
letters? And I have two individuals here. But before I ask them to come up, I have been touched by Mr. Blinko, not by him personally as much as by the support that he has here.
he had 6 people here. One has had to leave.
Mhm.
And you have many of the pieces of correspondence that basically cite him as a success story. This gentleman was a homeless gentleman before. Once he got through this cycle, he's become a volunteer, an amazing volunteer, to the extent that he had 6 people here in court all morning waiting to share with me and with you, Your Honor, and with him. It's been very emotional for him. But they're amazing. And 2 of them would like to share just a couple of comments.
Okay, and he's still at the Pay It Forward?
I'm sorry?
Is he still at the Pay It? Are you still at Pay It Forward?
Yes.
All right. And I understand that all of this started with allegations that the victims were selling drugs underneath the bridge. So I'm aware of all of these programs. So this truly is a success story. And I understand that there are issues that happen. I mean, next time you just got to call the police. You understand?
Yes.
All right. So who would you like to bring forward?
Brittany and Valerie.
Sure. Hello.
Good morning, Your Honor. My name is Brittany Ackerson. I am the Assistant Director of Courtroom in San Antonio and have been working with Mr. Thomas Linko for years. If you don't mind, I wrote some notes down. No. Okay. We've worked with him for a very long time, and he's done a lot for this community. So this is just a couple that I could pull off the top of my head.
Okay.
First of all, how he got arrested was he got his birth certificate and he was really excited. He's never had a Texas ID before. So in doing the ID recovery process, found out he had the warrant, and then waited outside for PD. When PD showed up, they knew who he was, and the police officer tried to go talk to the magistrate judge, but wasn't able to do that. So Mr. Blinko was living under the bridge for quite some time. And ran the bridge for quite some time. He got into inpatient treatment on his own volition. He came to us, said, I need to go to detox. I need to go to treatment. And I said, we like to test people. If they really want it, they're going to show up. So I told Blinko, show up tomorrow. And he did. And I took him to detox and treatment. He graduated treatment. He went into outpatient treatment on his own. He goes to AA meetings throughout the city of San Antonio and leads them. He shows up at Corazon and Cam literally every day to give back to his peers that he lived with on the streets. He's trained police cadets in homelessness, which I'm sure Val will speak more about. He shows up as a father to his children, his actual children, and his children out in the street as well. He's reconnected with family for the first time in years. He's encouraged people to seek treatment throughout the city. So this is where I'm going to try not to get emotional, but I will. So not only does he show up for his fellow peers homeless, that I appreciate you. My eyes are leaking. Thank you, sir. Thank you, Your Honor.
You're welcome.
So not only does he show up for his peers out on the street and direct them in changing their life, he knows the severity of what we do working with the unsheltered population and that we're surrounded with death more so than life. So as we are helping people, he comes in and supports us as well. He truly is a success story and a model in this community. And I'm really proud of him. That's all I have. Thank you.
All right. Thank you so much for coming down to show support. Hello.
Hello, ma'am. My name is Valerie Salas. I'm the Director of Homeless Services at Christian Assistance Ministry. I'm also a person with lived
I'll
experience.
slow down a little bit. That's okay. Don't be nervous.
I'm very nervous.
I think I may have met you before, but okay.
Probably I'm a person with lived experience as well. I've been sober, clean and sober for 9 years. I'm also the board chair president of the Lived Experience Advisory Board under SARA, which is South Alamo Regional Alliance of the Homeless. And I met Thomas in 2017, and I just want to say his transformation is we're in recovery. We're a program of action, not promotion. And he's wholeheartedly stepped into that. I've sat in with him, not just from I used to case manage him, but it grew into something more where we needed him and where the areas we needed him in is his story and testimony of the way he lives his life now. We partner really closely with SAPD. We started a cadet program with them where we actually train the cadets before they hit the streets to understand what it is to be, serve, the homeless, because many of the calls will be on the homeless. He's the first person we pulled in and testify and share his story with them, and he does those with us. He shows up every day to our campus to serve. I've sat in with AA meetings with him when he gets his sobriety chips and see the light that goes off when that happens. I'm sorry.
No problem.
But I personally, as a person with lived experience and a person who runs a campus that helps a lot of people, we need that light to show others that recovery is possible and that a second chance of life is possible. And Tomas is a living and breathing example of that. So that's really all I have.
Thank you so much. And thank you all so much for coming. So here's the number one question. He's probably not going to be released from the Bexar County Jail till 1 a.m. So is there going to be somebody available to pick him up? Okay, so everybody said they'll pick you up. All right. I appreciate the fact that we're back on the record. I appreciate the fact that you actually found out you had a warrant, turn yourself in. Most people who are not in recovery, they try to dodge things instead of saying, this is a problem, this is an issue, I'm going to face it head on. So I appreciate that. And the testimony that they've given to you reminds me of when I go to drug court graduations or graduations from treatment and see the changes in people. So I really appreciate that. All right. But next time, call police. Don't confront anybody. Okay.
Yes, ma'am. Whatever consideration you can make on the agreement based on those comments, we'd appreciate, Your Honor.
All right. So this is what the court will do. Court is finding you guilty. As previously stated, the enhancement true. Court will sentence you to 6 years in the prison, suspended and probated for 3 years. There's a $2,000 fine that will be probated. 200 hours of community service restitution probation. The community work that he does, once you get information about what he's doing in the community, you can count that towards his community service hours. And are you going to be staying at Pay It Forward? All right. So I'm going to put out here you to reside at Pay It Forward. Once they do their transitioning, which I know they do, just keep in contact with probation.
Yes, ma'am.
There's to be regular reporting by Zoom or in person, regular UAs and probation. Some of the programs that he's involved in, they do the UAs. So if you all want to coordinate with them on that, you can. And it's the same thing with field visits. I'm going to order field visits 4 times over the span of his length of probation. There's to be no contact. I don't know how he does the no contact if these persons are homeless.
One person is incarcerated, Your Honor, and the other is also on probation. But you're right, we'll waive that if that makes it easy.
All right, so we'll waive the no contact, but you know who the parties are. Hopefully, do not have any contact with them. If you see anything suspicious, then you'll just need to call the police. You understand? And he's to continue with his current treatment plan. And that includes the sober support meetings that he does.
The AA meeting?
Yes. They call them sober support meetings here, but they're the same thing.
Yes.
All right. And there's to be proof of employment within 60 days of release. There's to be.
Judge, he's on SSI and primarily volunteering his time.
All right. So you'll need to provide then proof of employment or either SSI within 60 days. There's to be no employment as a home health care provider or with minors. Probation. Is there anything else? No, Your Honor. Is there anything else you need from the court? All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. All right, we can go off the record. I'm going to return this to you so that he can have it. And great work. I'm glad that you have changed your life.
Thank you.
All right. Oh, I will. Oh, okay, I will. And you all, thank you. Can I have CR 11792, State of Texas versus Nelda Rios? Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Albert Chidas for Ms. Rios.
Are you Nelda Rios?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nelda Rios who was placed on deferred adjudication in 2022 CR 11792 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on April 19, 2023 for a period of 2 years? Is that you?
I still gotta say, I don't remember. I do have a head injury, but
All right. She doesn't remember that she was placed on deferred adjudication. Do you know when she had this head injury? Was it before or after she was placed on probation?
It was before, Judge, and she did remember earlier when we were talking. It's something that I was talking with the state and with probation about. She does have some deficits. She goes to Center for Healthcare Services for treatment.
All right. So do y'all think she's competent?
She has been. This is the first she says she doesn't remember being on probation, and we had actually talked about trying to help her because she was homeless. There's some issues that came up. She's on SSI for her head injury, but she lost her ID, and when that happened, she got evicted from housing. So we could work something out with Haven for Hope, get them to help her get her ID temporarily.
So are you all looking to withdraw the motion and alternate main conditions?
Judge, we thought that it would be better to come and have the motion heard, but again, that's up to you.
I think it would be best probably to withdraw and alternate main conditions.
Your Honor, we were looking to maybe getting some evaluations done while she was in custody.
Ah. So what evaluations are we looking at?
The TAP and mental health evaluation.
My only concern is I understand y'all want to do that in custody, but she's telling me she doesn't remember signing conditions or being on probation. She doesn't have a place to stay?
She was living under a bridge when she was arrested.
All right. So here's my question for you. One or two things can happen. You can remain in custody. While in custody, you will be evaluated. We can reset the motion to revoke, and you can be evaluated for the mental health caseload. Would you like to do that?
I already know that I'm not capable of, that I cannot. Like, you have to tell me all over again because I didn't understand it.
All right, let's do this. Why don't we see whether or not the mental health court will accept her? I know they only do pretrial diversions, but if nobody's going to object to it, I'm willing to do a motion for new trial. And we can start all over because I see I'm not the person who took this plea. So if you would check with mental health court to see if they'll accept her, because that may be the better placement for her, because I think she's going to need one-on-one care. So if you'll check with mental health court and let them know, and you'll have to let them know that she's currently on deferred adjudication, but I'm willing, if nobody objects, to hear a motion for new trial, grant the motion for new trial, because the key is to get her the mental health treatment. And this is a possession less than a gram case.
Yes, Judge.
Okay. So is everybody on board with that?
Yes, Judge.
Yes, Judge.
All right. So what I'm going to do is I'm going to reset you for 2 weeks. There may not be anything completed in 2 weeks' time because mental health court will have to interview you, but I just don't want to lose track of you in the system. Okay. Do you have any questions?
No.
All right. Do you have any family?
I don't. I have that sometimes I don't even have money to buy me a meal.
Okay.
I haven't been able to have a bank account with Bank of America, but because I don't have a 19, because when I got arrested, I was in my apartment, and it's a long story. But I had gotten a better criminal trespassing in my apartment, and that's why I got arrested for this case. I'm sorry for it.
Oh no.
And then we came to court and went through all this process, but being out, I don't even have money to buy me something to eat or pay for motor room because of everything I've lost. And I got arrested at the motel. And I know that I have had issues with mental health since I was 10 years old.
Okay. All right. So we're going to give you a 2-week reset. And that's just so I won't lose track of you. So now we have a plan. We're going to try to get you in the mental health court and probation. Could you see about the mental health case evaluation while she's in custody, just in case that doesn't work out?
Yes, sure.
All right. Is there anything else?
No.
All right, Ms. Ferguson, I need a 2-week reset on Nelda Rios, please. You're welcome. All right. So we're going to put it down for August 29th.
Thank you, Judge.
All right, Deputy, before you take her back, Ms. Ferguson, can you give her a reset form so she'll remember? All right. Are you all ready to go on the record?
Yes, ma'am.
All right. The court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Brittany Mitchell for the state. Amy Owen for the defense.
All right. And the other 2 attorneys who are here?
Yes, Judge. Brandon Wong for Alexander Reed.
All right. So everybody, please do not whisper because the court reporter cannot hear. So
Brandon Wong for Alexander Reed.
Yes, Your Honor. Rick Foster here for Dr. Javier Rodriguez.
all right. So before we get into the reason for the other 2 attorneys being present, I want to make sure that you have all the discovery from the state that the state has in its possession.
That the state has in its possession, I believe so, Your Honor. I do not know if that's what is in their possession is comprehensive of the order of the court of what was ordered to be turned over. I had not looked at that yet, since we do have a final discovery, I believe, setting, I think it's on the 24th.
On the 24th.
It's 24th.
So this was set for the motion to quash today, and we already have a discovery setting set on the 24th.
Okay. All right. So let's go over the motion then. And I have a first amended motion.
Yes, Judge. Do you need a copy?
Oh, I have this. And did you file a motion as well, or is
I did
this?
not, Your Honor. I found out about it yesterday, but we're subject to this motion because we're the doctor, one of the doctors that is being asked to produce records for Mr. Wong's client, Ms. Reed.
All right.
And Your
So
Honor,
defense.
Your Honor, so as the court's aware, we have argued, sort of argued this prior to the court, and we're not on a fishing expedition to for all of her medical records, but what we are interested in and looking for are medical records that occur between January 1st of 2022 up through January 31st of 2022.
All right. Do y'all want to write this down, what she's asking for?
I can get it.
Okay.
Let Mr. Wong know. So there's American Health Imaging on January 6th, 2022, January 18th with Dr. Nivra Beta, January 21st with Dr. Malhorta, and January 31st with North Central Baptist Hospital ER. And then we know that the outcry in this case is February 8th and 9th. And the reason we're asking for this, Your Honor, is that the mother of the complainant suffers from a frontal traumatic brain injury. We know that occurred in 2012. And those, because of, without revealing too much of our defensive strategy in this case, there's information contained within the case file of the civil discovery and within the court-ordered psychological evaluation by Dr. Richard Tice that gives us reason to believe that there could be exculpatory information contained within mother's medical records, mother's outcry witness in this case. And we believe that what is contained within those records could be exculpatory. We're asking for the court to do it. We're not asking for them to be turned over. We're asking if the court would do an in-camera review of these records to see if there's anything relevant to this case in terms of symptoms and diagnoses of what happened within the 30 days of outcry. And that's what we're requesting.
All right. And state,
Yes.
are you planning on calling this witness as an outcry witness or calling this witness at all?
She would be the outcry witness, Your Honor. And we had a hearing previously on this, and our position as to why we did not feel that these records were necessary was because she is just the outcry witness. She's not, the allegations themselves come from the child. The child said these allegations multiple times. And it's just very attenuated from how there could be any relevancy. It's kind of well, there might be something in there. And we don't know that there is. And it's the state's view that it's outside our duties to provide, which is why they chose to subpoena independently.
Well, the court's question, this brain injury, did it occur before or after the alleged outcry?
Before.
About 10 years before.
All right.
Judge, obviously they're asking for my client's protected HIPAA information. It's just clearly a fishing expedition. The subpoena is defective on its face. They actually didn't even follow the procedure. They didn't serve my client. They never served my client with the actual subpoena for any of the records they're asking for. The subpoena is incorrect because it doesn't even list her name correctly, her birthday correctly. So again, no one can even provide the information they want because again, it's just defective on its face.
But obviously, you know.
Obviously, I know about it, but and
'Cause
that's
you're
why we're
here.
here. But the reality is, Your Honor, as the state said, none of this information is remotely relevant. They're just trying to simply fish. My client, again, she's one of many outcry witnesses that have heard the child's statement. She's not the victim. She's not saying this happened to her.
But this is the person that the state is calling as an outcry.
I get it, Judge. But again, she's not the only one. And then they're still able to have my client on the stand, ask her whatever she wants, whatever they want. You know, that is, we all know that is how it works. And so they're able to get whatever information. They're trying to link something that happened 10 years ago and saying, well, now she got some sort of mental handicap where she is now convincing her child. And, you know, that's their strategy. It's not even a secret. They're trying to say that she has influenced her child to say that these allegations have occurred to her. It's a stretch to say the least, Your Honor. And so again, it's just harassment on part of, you know, they're just making my client spend countless dollars and time fighting this thing. She has nothing to do with it. All she did, she made a report and that's it. She's out of it. And so again, for them to now seek all of her records, you know, now they're cutting it down. Originally it was her entire medical file, her entire medical records. And I understand they just want a couple visits here and there. But again, Your Honor, my client's still going to have to produce them. It's a hassle. There is nothing relevant that's going to come from this. And they're keeping it's possibly exculpatory. They don't know. There's nothing other than just their speculation. It's just pure speculation that they can come up here and say, you know, we just want to harass this lady to get these records just so we might be able to strengthen our defense. And again, as the prosecution has said, it's just not relevant.
Okay. And do you have an argument?
Your Honor, we just merely support the patient, Dr. Rodriguez's patient, Ms. Reed. It's her record. She doesn't want to produce them. We don't want to produce them. And it sounds like from the summary that was given by defense counsel, they're not even asking for Dr. Rodriguez's records at this point. Is that correct?
That's correct.
Okay, so we have a subpoena, but you know, so we need protection from that subpoena. I can file a separate motion, or we can agree on the record today that it's, or as the court determines, that subpoena is withdrawn.
Just 1 second, because I'd like to.
Oh, yes.
Cut to
Yes,
the
Your Honor.
point.
Okay.
So this attorney, his patient, or his doctor.
Yes, Your Honor.
Are there any records that you want from this doctor?
I don't believe so, Your Honor. However, since we don't have any, we don't know if it references, you know, any type of diagnosis or treatment that's referred back to that. But these specifically, what I read are what we're requesting.
All right. So here's the thing. Number one, he's saying that the subpoena is improper on its face because it doesn't have the correct name, the correct date of birth. I think we all know who it is and who we're here for. If you want to make another trip down to the courthouse and they can correct the name and the date of birth, they can do that. But I can tell you what my ruling is going to be. What my ruling is going to be is yes, I need to see it in camera inspection, and I will make a determination of whether it's relevant or not. If I deem that it's not relevant from the in-camera inspection, then that will be the end of it. But I can't make a determination on whether or not a record is relevant or not until I see it. So just listen to everybody's argument. I've listened to your argument, but I need to see what it is. So she is telling me she has narrowed it down to this specific thing. And my understanding from both sides, or let me make it clear to everybody, that's the specific thing. We're not going outside of that specific thing. So counsel, if there is something that you feel that the attorney who's here today, that there is something that they have, let them know specifically what it is. And then if you all will present it to the court, not to the state, not to the defense, just present it to me, I will review it. And then I will make a determination whether it's relevant or not. And my understanding from defense, they're no longer asking for the entirety of the record, which I would think the entirety of the record would not be relevant. But the specific parts she's asking for, I'll review them and make a decision on that. So first question, are you going to want me to rule that on its face because it has the wrong date of birth, wrong name? And just
On its
say,
face, Judge, honestly, yes, Your Honor, they need to refile it.
all right. So
And then
this
I'll
is-
ask my client, once they've served a proper subpoena to provide said documents, and then, because I understand what your ruling is, but obviously I can't agree to release her records when it's just not been properly done.
all right. So when will you have your subpoena ready?
Today.
All right. So she's going to have her subpoena ready today. So while she's getting her subpoena ready, if y'all can get those records ready for the time frame, if you give them the time frame, it's not, I read very quickly. It's not going to take me long to do it and to review everything.
And Your Honor, I think the other issue would be that in order for anybody to get the records, that the court would need to order Mr. Wong's client to sign a HIPAA release to the actual entities to be able to release the records to the court.
I'm not going to order her to sign a HIPAA release.
Okay.
So
once we get the subpoena and then the court, we would direct the entity to send the records directly to the court.
yes.
Okay.
And then if you all are able to get the records directly to make the process move quicker and bring them to me, and I will review them in camera. And as I said before, when I review things in camera, I really review them in camera. Defense doesn't see it, state doesn't see it, her client's not going to see it. I'll be the only person who's seeing it.
May I address?
Sure.
Your Honor, pursuant to HIPAA and the CFRs underneath that, we have, if it's a third-party subpoena, to be able to release the records, we need to be ordered to produce those records. And then there needs to be provisions that they're prohibited from using the records and disclosing them outside the litigation, and they're required to return the records upon the conclusion of the proceedings. So
Here's
may I pass something up to the court?
Sure. But you may pass it.
Yeah.
But I will tell you, I don't believe in crossing bridges until they're built.
Yes.
So the first thing we need to do is, if you all will confer on the date she's speaking about,
yes,
and then she can have her new subpoena, and you all just get the records prepared for the court. And if you all can have the records and bring them to me, because sometimes when things are mailed to the court, it goes to 6 different places. People don't read 187 4th floor with a suite number. So it goes to different places. And so nobody else will read it, just me. If y'all will bring it to me, and if you could put it in a sealed envelope that says judge only on it, nobody else will open it. The staff would not open it. It'll go specifically to me.
And can we go ahead and submit an agreed order on how those records are being tendered up to you, because you've directed us to do it?
Sure.
And
If you
put
all
it
can-
with the documents?
Yes.
Okay. You okay with that?
Yeah.
Okay.
All right. And then she'll get the subpoena. But I will tell you, our next court date in this court for discovery matters are August 24th. So if you all can have all those records to me before August 24th, that would be great. If not, I can read it on August 24th, but I just like to have leisure reading before that date.
Okay.
All right, so August 24th. Does anybody need anything else?
No, Your Honor.
No, Your Honor.
All right, and if there's not any objections from the defense, if you all want to appear by Zoom, you're more than welcome to appear by Zoom as long as I have the records to review in camera. Is there going to be any objection?
No, ma'am.
All right, so if you all would like to appear by Zoom, just let the court know. The court coordinator will give you the Zoom link.
That'll work. Thank you, Judge.
All right, thank you.
Thank you, Your Honor. May we be seated?
Yes. Court is calling 2023 CR 6161, state is Texas versus Sean Griffin. Could I have parties announced for the record for the state?
Travis Banks for State of Texas.
Defense?
Samuel Lyles for defense.
All right, we're here for a motion to modify bond conditions. They're requesting tracking only. Do you have an objection, state?
Without further information, yes.
All right, have you conferred?
Judge, we have conferred. He's currently on partial because he does have a full-time job, but he just actually graduated from barber school.
Yes.
And so he's looking to do tracking only to be basically a barber that can travel around and do haircuts, because currently he's just in his mom's bathroom doing the haircuts. Good. And I do have one witness, Judge.
All right, if you'll call your witness.
Takesha Harris.
All right, and you want to put your drink down?
Yeah, sorry.
Sure, no problem. Everyone needs to whisper. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Takesha Harris.
All right, defense.
Miss Harris, you know why we're here. What's your relationship with Sean Griffin?
I have his 5th child.
I'm sorry,
I
what?
have a child with him.
Okay.
And how many children does he have?
He has 5.
And in regards to his financial situation and the children, can you just tell the judge what's going on?
Well, ever since this has started, it has put a dent on everything. My daughter goes to IDEA, so they have no buses. So to pick up and drop off has been hard because I have no one to do it. So I haven't been able to really work. Financially wise, he hasn't been able to really do anything because he can't go anywhere, provide how he used to. I have photos of how much of an active father he is to all of his kids. He has 4 with someone else, and then he has 1 with me. He gets his kids all the time. We just had them. It's just we haven't been getting them a lot because he can't go anywhere, and I don't want them just to be sitting in the house. But I just need help with being a parent, and most of this for him to be there for his kid, because he missed my daughter's graduation. My daughter had surgery. He couldn't go. He missed his oldest son graduation to go to high school. So want help. He's not a violent person.
And Ms. Harris, in regards to his children, does he financially support them?
Yes.
And how is the GPS hindering his ability for the children?
This is the first school year. He didn't get to get anything for the kid because we've been having to pay for things. So he won't go back to jail because he was behind on his bail bond and stuff like that. And me and his mom have been doing as much as we could.
And what are his sources of income?
He was working. He had just got promoted at his job at security, but he lost that. So he just started working at Toyota and barber. He is a really good barber. That's where most of the money was coming from. And he just passed his test. So, but there's so much that he can do.
So he's a licensed barber. Is he traveling around? How is he doing haircuts?
Right now, he was doing them in his mom's restroom because he can't go anywhere. And he really can't cut at school that much anymore because he graduated.
And if he's able to travel, is that going to help him make more money for his children?
Yes, and to be there for them to pick up from school or anything.
Thank you, Ms. Harris. No more questions, Your Honor.
Any questions?
Yes. What hours does he need to be able to travel to?
That it just depends. Different people call different times. And oh, I'm so sorry. Different people call at different times. And with helping with my daughter from school, she has to be at school at 7:45 and school ends at 3:45. But we get there a little early because she goes to IDEA and they don't have no school buses. So the lines be long. It just really depends on who calls and asks him. Sometimes he goes in the middle of the night, sometimes it's during the day. It's just he makes more traveling because there's not really a lot of barber that travels.
So he wants to be able to travel around even in the middle of the night to cut hair.
Well, right now he works overnight and then he works during the day also. He works 2 weeks in the morning, 2 weeks at night, and then it switches back 2 weeks in the morning, 2 weeks at night. But my main thing is to be there for his kids also because I'm literally a single parent and his mom works at a school too, so she works at a different district, so her hours are the same as the hours that I need help with.
And do you two reside in the same household or?
Not anymore, no. He lives with his mom because of
and so you also want him to be able to take the children to school and
Yes.
home from school.
he missed my daughter's graduation and my daughter has surgery, a major surgery, and I have to literally do it alone and take care of her because he couldn't be there to help.
Okay, no further questions.
All right, anything else?
No, Your Honor.
All right, thank you. All right, you can come back here. All right, any other witnesses?
No, Your Honor.
All right, the court will hear argument.
Your Honor, in regards to his situation, he's a very involved parent. He has 5 children. He's trying to be there for them, not just financially, but to take them to basketball practice, make sure they're in school, doctor's appointments, whatever it is. In addition, he does have a full-time job at the Toyota plant, but to support 5 children, it's not exactly making ends meet. So he needs to be able to travel as a licensed barber so he can go around and do his haircuts and make extra money.
State.
Your Honor, with regard to the school participation, the state does have no objection to him, helping out with taking the kids to school and that sort of thing. With regard to the mobile barber business, during business hours, that sounds like a fine activity to be doing. I am a little concerned that the witness did say that even in the middle of the night, sometimes he'll be out cutting hair. I don't think the court should approve that, but doing barber business during normal business hours, I don't think the state objects to that.
All right, so I will allow you to work upon proof of employment and work hours and to attend all children's school and medical appointments. Your work hour, it's going to be a curfew for that unless it's Toyota. And I think, what time would you like the curfew?
I mean, for the barbering business, I guess 6 p.m. would maybe reasonable.
Yes, are you able to do that?
Yes, ma'am.
All right, work hour curfew as a barber will be 6 p.m.
And Judge, could we just note, because I talked to pretrial in situations like this before, and they want to see an LLC or some DBA on behalf, but he's going to be a sole proprietor because it's his own business. There's no way to put a note that he's a licensed barber. And
If you would speak to the coordinator, she'll have pretrial services officer zoom in. If you know who is pretrial services officer, we'll have them zoom in and so they'll understand the court's order.
Okay, perfect. Thank you,
All
Judge.
right, so just talk to the court coordinator about that and she'll have them zoom in.
Yes, Your Honor.
All right, is there anything else?
No, Your Honor. Thank you, Judge.
You're welcome. Hi, thank you. The prosecutor on this case? Court is calling 2021 CR 0835, State of Texas versus Nicholas Cornelius. Can our parties announce for the record for the state?
Daniel Escobar from the state of Texas.
And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge, we're going with the lesser included offense robbery.
Any objection?
No.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge, I believe he's competent.
Do you believe he's currently, yes, do you believe he was legally sane at the time of the offense? Mr. Cornelius, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of robbery, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers exhibit 1 and all attachments. No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have a charge reduced to robbery and was even.
All right, thank you. Oh, you may be excused to continue to confer. Mr. Cornelius, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we're waiting to get back.
All right. Anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right. So everyone, please whisper in the box. We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winston District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922N. 18 USC 922N. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he were to be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right. That is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right. Are you employed?
Yes, ma'am.
What do you do?
Pack and moving, Apple moving service.
Okay. All right. This is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any, to FedEx. Regular reporting. By Zoom or in person. Regular UAs. 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits, 1 time per month for 3 months. And probation, if you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, Aubreyreed, Charlie James Ray Perkins, Amari, Emari, Lafel, Lafel, Freeman, Freeman. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else he needs? Yes. All right, is there anything else you need from the court to have black excellence in your life?
I'm out. Just maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
I'm out.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself 2 questions. 1, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right, Trinidad Counsel, have you received all the discovery in this case, and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Green, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on the lesser included charge of assault, bodily injury, married cohabitation.
Any objection?
No objection from defense, Your Honor.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation as a Class A misdemeanor?
Yes.
The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your
Do you
Honor.
believe he's currently competent and was legally sane at the time of the offense?
I believe that he is and he was, Your Honor.
Mr. Green, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea? Defense, is that the plea?
That is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge, there have not.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be no contact with Jesse Wheeler, Jessie Wheeler, the BIPP program, and anger management. Did you understand those were conditions that the state is recommending and the court does not have to follow that? Then to the lesser included offense of assault, bodily injury, married cohabitation. How do you plead? Guilty, not guilty, or no contest? State, any evidence?
The state offers State's Exhibit 1 in all of its attachments.
Defense is reviewed, Judge. We have no objection.
And state, have you talked to the complainant?
We have previously, Your Honor, in complete candor, this complaining witness has signed an affidavit of non-prosecution and was uncooperative with our case.
All right, thank you. You may be excused.
Thank you, Your Honor.
All right, Mr. Green, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements or police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. In regard to the no contact order with Jesse Wheeler, the parties are cohabitating. They do share a 5-year-old son who just started school yesterday. My client works at Pepsi during the day. Mother works for Rackspace at night. So the no contact order would impose an unduly burden on the parties in respect to parenting this child. As is usually the case, Your Honor, in these situations, CPS was involved as per family-based service plan. The parties went to counseling. My client went to counseling and is continuing to go to counseling. Both parties have been and are attending marriage counseling at this time. My client says that it's been a good influence on both them and their relationship. And they feel that the no contact order, if implemented, as mentioned, would be a burden not only on their relationship, on their status, but their ability to parent the 5-year-old child. So we respectfully request that the court not order a no contact. Thank you.
All right, so is this a son or a daughter? Because I was reading the report, it was a daughter.
Little girl, sorry.
Okay, no problem. I want to make sure I have it right. So what family members do you have in Bear County?
I have my mom, my dad, but my dad, he doesn't really help out much. My mom, she really can't because she can barely move around herself. Oh, I'm sorry. My dad, he doesn't really help. And my mom, she can't because she physically can't move around to help watch my 5-year-old.
All right, so here's the thing. I'm not going to do a no harmful or injurious contact. If there wants to be a no contact order, then the complainant can appear by Zoom or either in person. I want you to understand something.
Yes, ma'am.
I read the police report, and in the police report, you said she was pushing your buttons, you're pushing her buttons, and you can unfold your arms. And all of you all were acting not as adults, y'all were acting like children. And the child at the time was 4 years old. You all caused drama and trauma to a 4-year-old. What is a 4-year-old supposed to think? And you and the complainant are going through the apartment, throwing things around. And you tell a 4-year-old, don't throw that, place it back where it's supposed to be, and trying to lay down the law to a 4-year-old. And you all are acting worse than the 4-year-old. And that's a memory that 4-year-old is going to have forever. No amount of counseling that you all go to try to put your life together is going to take away that the 4-year-old witnessed all of this drama in their life. So if he wants to have contact with the mom and they're working things out, she needs to appear by Zoom and the court will consider it. If you want to get her to Zoom in here today, then I'll consider it today. Is she able to Zoom today?
She's asleep because she works at night.
Oh, well, if somebody wants to call her and have her Zoom in.
I can call her.
All right. So it's going to be 2 years deferred adjudication, affirmative finding of family violence, no contact with Jessie Wheeler. Of course, if you call her and she Zooms in today, I'll reconsider. The BIPP course, 80 hours community service restitution. I'm going to order parenting classes. If you've done parenting classes through CPS, that will be acceptable. If you have not, then you'll need to do parenting classes. If he's completed parenting classes related to this incident through CPS, then the community service hours will be deemed to be satisfied. There's to be anger management. There's to be CPS compliance. It sounds like it's a safety plan. So whatever the safety plan is giving them, just make sure he's doing that. And probation, if what he's doing for his CPS safety plans coincides with what I'm requesting, then the CPS, what they're doing will be enough. There's going to be regular reporting by Zoom or in person, regular UAs, and field visits one time. Well, field visits, I want at least 3 field visits throughout the entirety of his probation. So you only have to do 3. If you deem that there's something that's an issue, then of course you can do more, but a total of 3 field visits throughout his probation. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else you need? Jessie, Jessie, Wheeler, Wheeler. That may not stand if he's able to get her to Zoom in. Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? We can go off the record. Here's the thing. When there is violence in a home, children learn how to behave, right? So if somebody wins an argument by being violent, guess what? A child realizes, hey, if I want to win an argument, I need to be violent. Or here's the thing, you have a daughter. A daughter will think that you love her mom, right? You love her. So a daughter will begin to think, oh, This is how somebody who loves you shows that they love you. They're abusive. And then your daughter goes out in the world. And if she ends up with, as my professor in high school would say, and I say professor because he was a doctor who taught us physics, he would always say, girls, do not end up with a joker. So your daughter may end up with a joker. Don't let her be the reason she ends up with a joker. And he would give instruction to the guys too. So you've got to do better. You understand?
I understand.
All right. Thank you.
Thank you, Judge.
You're welcome. Michael Ball. Good morning. All right. We're going to go on the record. 2023 CR 3544, State of Texas versus Garland Green. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense.
Robert Gear for defense, Your Honor.
All right. And you're Garland Green.
Yes, ma'am.
Any objections to Mr. Gear appearing by video, state?
No objection, Your Honor.
All right. And any objection to Ms. Wheeler appearing by video?
No objection from the state.
All right. Ms. Wheeler, what are you wearing?
Clothes?
Oh, okay. All right. I just saw a shoulder. Like, please have on clothing.
Yeah, I do.
All right. So there was a no contact order that was put in place by the court. And I informed both parties that I would reconsider if you appear. So if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You all can, excuse me, sir, Mr. Pettis, if you all can move down to that end. All right. If you'll state your name for the record.
Jesse Wheeler.
All right, Ms. Wheeler, I'm being asked to consider allowing you to have contact with Mr. Green. Has Mr. Green been staying with you since this incident?
Yes, off and on.
Are y'all currently living together?
Yeah, I guess you could say that.
All right, here's the thing. I'm not trying to trap anyone into the fact that they may have violated some sort of orders. I'm just trying to figure out whether or not he should be allowed to have contact with you. That's all I'm here for. So have you all been living together?
Yes.
All right. Have y'all been living together since this incident?
No.
All right. When did y'all start back living together?
We were told that the order was lifted. God, I think back in, I don't know, because CPS got involved and then she said the order was lifted. So that's when we were actually able to start staying with each other again.
And when was that? Has it been this month?
Has it been this month?
Yes.
Yeah, this month, last month. So.
All right. So are you all in counseling?
Yes, we are.
Couples counseling?
Marriage counseling, and we both do counseling separately.
All right. Do you wish for Mr. Green to continue to stay at the home with you?
Yes.
All right. Any questions?
No question from the state.
All right, then I'm going to change the order to no harmful or injurious contact with Jesse Wheeler. Miss Wheeler, if there are any issues at the home, you can just let his probation officer know. Do you understand?
Yes, ma'am.
All right. Is there anything you need from the court?
No, ma'am.
All right. Anything else?
Okay.
All right. Thank you.
Thank you, Judge.
We'll close the record. Thank you, Mr. Greer. You can have a seat.
Thank you, Judge.
All right. Thank you, Miss Wheeler.
Thank you.
All right. Is there a plea just on one of the cause numbers?
Yes, someone.
And this is an application. Court is calling 2023 CR 5148, State of Texas versus James Ray Hernandez. Can I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense.
Afternoon for defense.
Are you James Ray Hernandez?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
with the enhancement allegation?
Oh, sorry, Your Honor. We're waiving the repeater enhancement and proceeding only on the indictment.
Any objection?
No, Judge.
Mr. Hernandez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine to be probated. State recommends deferred adjudication. They're taking in consideration 2023 CR 5149. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense? Is
Yes,
that the plea? State?
Yes, Your Honor.
And also there's an anger management course. State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 6 years. There be the DDRF, 80 hours community service restitution, NIC evaluation, no contact with Joe Ray Hernandez and Rosalinda Hernandez. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer State's Exhibit 1 and its attachments.
Any objection?
No, Judge.
State, have you talked to the complainant?
Yes, Your Honor. The state has spoken with the complainant and they did ask the state to push for drug treatment for the defendant. And one other thing I want to mention about the repeater enhancement that the state waived. As far as the state can tell, that is not a case that's in his criminal history. I'm not sure how it made its way into the indictment, but the reason, a big reason it's being waived is because it's not part of the scope.
All right, thank you. All right, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. This is what the court will do. Well, let me ask you this first. Do you have children?
Yes, ma'am.
What are their ages?
13, 7, 5, and 4.
13, 7, 5, and 4?
Yes, ma'am.
And do they live with their mother? Who are they living
My
with?
first 3, their mother passed away. They live with my ex-mother-in-law, and then my 4th lives with her mother.
Okay. All right. Have you ever had any mental health diagnosis?
Yes, ma'am, I have. I've had about 6 in the last 4 years.
And what is the diagnosis?
That I have no problems, I guess. I've been to Laurel Ridge, I say behavioral. I actually had one for my last charge of discharge of a firearm from 2020, which was the most recent, and they dismissed that case in March of this year.
It's my understanding that's the only
Yeah.
prior charge he has. Was
All right. So does he suffer from mental illness or not?
Not that I'm aware of. My understanding the state wanted to have him evaluated.
All right. So what happened this day? Was that drug induced? Were you using drugs that day?
No, ma'am, it was not.
So you're telling me that his family think there's some drug issues or mental health issues?
In our communication with his mother, she does believe that there's some drug issues and that he would benefit from drug treatment.
He did attend Laurel Ridge. That was for an inpatient treatment. There was a history. There has been a history of drug usage. He went through CPS as well.
Oh, and lifetime recovery outpatient, Your Honor.
Okay. And what drugs were you using at that time?
Just methamphetamine.
All right. This is what the court is going to do. It's a $500 fine to be probated, 6 years deferred adjudication, taking consideration 2023 CR 5149, affirmative finding of family violence. There's to be no contact with Joe Ray Hernandez or Rosalinda Hernandez. Anger management. There's to be no unsupervised contact with minors. There's to be a TAP evaluation, MIC evaluation, DDRF evaluation, and that's to take place in custody and follow all recommendations. And there is to be proof of employment. Are you receiving any type of SSI?
No, ma'am.
Proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. The UA hotline until further notice. And field visits 1 time per month for 4 months and then as needed. If he gets a case manager early on, then probation, you can stop with the field visits. Probation, is there anything else just 1 second. We're going to do 80 hours of community service restitution and parenting classes. Once he completes those, the community service restitution will be deemed satisfied. Probation, is there anything else he needs? Is there anything else you need from the court?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Hernandez, in this court, in order to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel that the probation officer is not addressing that, you can always come to court. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge. You have a good day.
No, ma'am,
Why not?
because I'm homeless and I've been living pillow to post.
I'm sorry, I can't hear you. What did you say?
I'm homeless. I just got out of jail like 3 weeks ago, and I've been trying to get somewhere to stay and figure out how I'm gonna be able to get back and forth to classes, because I also have CPS going on as well.
Mhm.
And I don't have any money, don't have a job. and I've been looking for one, so I had to wait till my uncle or someone sent me money to give me an Uber. Cause
I mean, if you take the VIA bus, it's cheaper than an Uber.
yes, ma'am, but staying on 1604, there's no VIA buses.
See, that's where people call their city council person and tell them there's no VIA bus off of 1604.
I don't know who the city council is.
Oh, everybody should know who their representative is. People use their phones for so many things, but unnecessary things. And then when it's something important, and this is just not for you, this is for everybody to do this. When you ask them, who is your state representative? Who is your US senator? They're like, I don't know. I'm like, Google it. You can put your address in and it'll tell you who your city council person is. It will tell you who your commissioner is. It will tell you who your state representative is. It will tell you who your US House representative is.
Who are all those people, if you don't mind me asking?
It would have to be whatever your address is. Everybody doesn't have the same city council. Everyone doesn't have the same commission.
Sorry, because I don't know what that is. I'm sorry.
No.
I apologize.
No need to apologize. You know what? My mom always says, you should learn something new every day. If you did not learn something new, then your day was wasted.
Yeah, I learned something new today.
See, there you go. So if you have a phone,
Yes, ma'am.
if you Google in your phone, your address, and if you just put in, I'm very country, so I will put in who's state representative for, and you put in your address, and it'll pop up. Every person that you're allowed to vote for will pop up and you'll know who it is. I can't tell you who it is because I don't know your address, but the commissioners, they're divided up for distinct people. And you can call the commissioners and say, because commissioners court, they're in charge of city maintenance per se, or county maintenance per se. And they will be, if you go to them when they have a commissioners meeting and you say, we need some more VIA buses off of 1604, then they'll do it.
Oh, okay. I was so lost. I'm sorry. I'm thinking something about court or something. You're talking about calling them to.
Yes, so you can get to court on time.
Yes, ma'am.
All right.
I apologize.
All right, and that purse, isn't that a Michael Kors?
No, ma'am, it's not. And I have a Michael Kors like this.
See, we got to spend money where we need to spend money. All right.
This is old.
That's okay. I mean, sometimes we got to let things go so we can get to where we need to be.
Yeah.
All right, 30 days reset. Do you have all the discovery? Did you tender an offer?
We did tender an offer, Judge. I don't know if we've done the discovery acknowledgement yet, Judge.
Judge, we're still working through that. I believe that I do have it. Just need to work through it, but 30 days is what we asked for just because it's for setting.
All right, Ms. Ferguson, on this due plea deadline date in 30 days, that'll give you time to make arrangements.
To get here?
Mm-hmm.
Oh, yes, ma'am. Yes. Of course.
All right, Ms. Ferguson.
September 19th.
September 19th. They'll give you a reset form, then you're excused.
Okay, thank you.
Thank you. And if you walk downtown, there are plenty of places that are looking for people to work.
Yes, ma'am. I've been looking since I got out of jail.
Okay.
They've been asking me about like my background and stuff since I got these.
Oh, well, they actually, what is the place where they're doing it for people who have history, criminal history?
I can double check and give it to her before she leaves.
You'll have something before you leave.
Okay, thank you.
We're a full service court here.
Yeah, this is my first time being here, so I don't know how to do anything.
Okay.
I'm new. So,
All right, we're gonna make it happen.
Okay, thank you.
Yes.
Judge, the complainant. Yes. Garland.
Could I see the file on Garland, please? Location, are you all ready to proceed?
Yes.
Court is calling 2023 CR 6038, State of Texas versus Richard Gabriel Ramos. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Marshall D. White for Mr. Richard Ramos, the defendant, Your Honor.
And are you Mr. Richard Ramos?
Yes, ma'am.
All right, Mr. Ramos, I'm going to need you to speak up so the court reporter can hear, okay? Counsel, have you received all the discovery in this case and did you review it with your client?
I believe I have it this time, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Are you proceeding with the enhancement allegation?
Yes, we are, Your Honor. Judge, just.
Sorry. No, my fault. Mr. Ramos, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of assault of a public servant bodily injury? If the enhancement allegation is proven to be true, that will be a second-degree felony. The range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand?
Yes, ma'am.
All right. I'm going to need you to speak up, okay?
Yes, ma'am.
All right.
I didn't even know the text, okay.
Oh, that's okay. All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe he was, Your Honor.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you agree that you've been previously convicted of a previous felony. Punishment is to be assessed at 7 years in the prison. There are no applications. The state will take in consideration 2023 CR 6039 and 712653. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Mr. Ramos, showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
What was that again, ma'am? Sorry.
All right. Did you understand the waiver of appeal paragraph that you signed? This paragraph where your signature is listed. Did you understand it?
No, can you read it again?
I'm sorry, what?
No, can you read it again?
What did he say?
He said, no, like, can you read it again?
All right. So, first of all, did you sign this?
Oh, yes.
Did you go over it with your attorney?
Yes.
All right. When you sign this, what you're saying is that you are waiving your right to appeal. And waiving your right to appeal is, in layman's terms, waiving your right to complain about a sentence. Did you understand by signing that you're waiving your right to appeal? Now, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. You understand?
Yes.
Did you understand that?
Well, I didn't understand the appeal, no.
All right. Do you understand it now?
Yes, ma'am.
Do you still wish to continue?
Yes, ma'am.
All right, counsel, have there been any such motions?
No, they have not. But I will just say, Judge, with respect to this, it's the same documents, certification of your right of appeal. It's the same thing. Okay, you understand? The judge goes along with it. You just have no right to appeal. I did explain that to you. Yes. Okay.
All right. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Contest.
And to the enhancement, how do you plead? True or not true?
Enhancement is a prior conviction.
What do you mean, like the enhancement of
The prior conviction.
Oh, yeah.
Did you review?
You have to say true or not true. Is it true?
It's not true.
It's not.
All right, so I'm going to read it to you and I want you to answer if it's true or not true, okay? It says, And it is further presented in and to said court that before the commission of the offense alleged above, and when they say offense alleged above, they mean what you're here for now, on the 16th day of July 80, 2010, and cause number 2006 CR 9302 in Bear County, Texas, the defendant was convicted of the felony of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams. So is that true? Were you previously convicted of that felony?
Yes, ma'am.
So do you plead true to that?
Well, yeah, that I wasn't, yeah, that I went to prison for that, yes.
All right. So is it true or not true?
True.
Okay. State any evidence to support the defendant's plea.
Yes, Your Honor, State Exhibit number 1 with all its attachments.
Any objection?
No objections, Your Honor.
Mr. Ramos, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand that today the state is going to be presenting their evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, we ask the court to follow the plea bargain that Mr. Ramos has entered into with the state of Texas.
All right, Mr. Ramos, it appears that you were having a bad day.
Yes, ma'am.
All right, do you have any mental health issues?
I don't know.
Prior drug issues?
I had an evaluation for DWI.
Okay. All right. The court will follow your agreement. The court will sentence you to 7 years in the prison, give you credit for any time served, take in consideration 2023 CR 6039 and County Court Cause number 712653. Counsel, is there anything else with regards to sentencing?
Your Honor.
All right, Mr. Ramos, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Ramos, do you have any family in Bear County?
Ma'am.
Do you have any family here?
Yes, yes.
Do you have a support system?
Yeah.
All right.
So yes, yes, ma'am. Yes, ma'am.
Thank you, counsel. So when you get out of prison, you need to make some changes, because otherwise, if you pick up a new offense, your attorney, I'm sure, has probably told you this. I know he probably did. You will be listed as a habitual. And if you're listed as a habitual and you pick up a felony, depending on the felony it is, your minimum sentence would be 25 years. How old are you?
34.
All right. At some point, you're going to get to the point where I am, which is I'm in the twilight of my life. You only have about 20 more years before you're in the twilight of your life. Don't let the majority of your time have been spent in prison. You understand? All right. Good luck to you.
All right. Thank you.
Good luck,
You're
Mr.
welcome.
Ramos.
Okay. Court is calling 2019 CR 6497A, State of Texas versus Mark Anthony Rodriguez. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Joseph Stateson.
And are you Mr. Rodriguez?
Yes, ma'am.
Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
I did review, understand this.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Okay. Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find. I'm sorry, just 1 second. See, this is what happens when you multitask. I'm reading the police report plus giving him instructions. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Absolutely.
Are you a U.S. citizen?
Yes.
Who's the no contact order against?
Oh, sorry, I think I added that.
No problem. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to plea, punishment is to be assessed at 8 years in the prison. There are no, the state is silent on your application. There's to be restitution, if any, to Jose Montoya. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
All right, and the court, if the court finds there was a deadly weapon, then the court will find there's an affirmative finding of deadly weapon. Do you understand that as well?
Yes.
Okay. Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your
Counsel, have there been any such motions?
I had filed some motions. Because we worked a deal out, for the record, I think we had 13 prior settings with Randy Martinez who did not file motions.
Okay.
I expedited motions being filed, but my client had accepted an offer. So I don't believe the motions had been presented for a hearing.
All right. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence?
State offer states Exhibit 1 in all attachments.
No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments or review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. This will come back on August 12th. We'll do a PSI and TAP evaluation. At that time, the court will make its decision on your application based upon any evidence that's presented and also the PSI report. Yes. I'm sorry, October 12th. I'm just seeing if everybody's listening to what I'm saying. So we'll bring you back on August 12th, okay? I keep saying August 12th. Why do I keep saying that? It's been a long day. October 12th. That's when we'll bring you back. And Justice Stateson's so nice. He was trying to interrupt me without interrupting me. Because no matter what you say to Joseph, his level stays here. He's like,
I don't raise my voice.
it's like that day has passed, so we're going back in time. All right, we'll see you then.
Thank you.
Thank you. Have a seat, Chris. Watch somebody's.